All rise. Division 2 of the Court of Appeals of the State of Washington is now in session. Chief Judge Rebecca Glasgow presiding. Also sitting Judge Ann Cruiser and Judge Brad Maxa.
Please be seated. Thank you. Good morning. We are here a little late this morning for our first case, Kertchen versus Washington State Patrol. We have not yet tracked down the attorney for a respondent, but oral argument was scheduled for this morning, and so, Mr. Kertchen, you are welcome to give your argument.
Thank you, Your Honor. May it please the Court, good morning. Vitaliy Kertchen, President Pro Se. In this matter, in June of 2021, I filed a request with the Washington State Patrol for I filed a public disclosure request with the Washington State Patrol for a disposition report from the Linwood Municipal Court and the King County District Court. I received a response which stated the State Patrol would not disclose the requested records because of an exemption. There was a little bit of confusion as to what exemption applied. The State Patrol responded with both that criminal history record information is disclosable under the Criminal Record Privacy Act, and then also cited RCW 4343.710. When it came time for the trial court, the State Patrol relied solely on RCW 4343.710, and the trial court agreed that such a statute provided an exemption to the records I requested and denied the lawsuit. And that's why we're here today. Now, the Public Records Act must be liberally construed, and an exemption applies to a records request only if that exemption is explicit, clear, and unambiguous. It is important to consider that although I'm the appellant in this matter and the burden is on me in the appeal, really the agency the agency has the burden of proving that a valid exemption exists to the public records request. Again, in this particular instance, the State Patrol relied exclusively on RCW 4343.710. Now, if we look at that statute in the very first sentence of it, it states, information contained in the files and records of the section relative to the commission of any crime by any person shall be considered privileged and shall not be made public or disclosed for any personal purpose. On first glance, it does seem like that statute is the end of the conversation and provides an exemption to the records that I requested. However, that's not the full story. We also have to consider the full statutory scheme. And the statutory scheme, when it comes to criminal records, is partly in 4343, but also in the Criminal Records Privacy Act, RCW 10.97. And the CRPA, Criminal Records Privacy Act, is a much more comprehensive. It's much more comprehensive in general. It has a lot more, many more definitions, many more operative sections in terms of what records are subject to dissemination, what records are not subject, under what conditions certain records are subject and are not subject. And
so why doesn't 1097 displace the Public Records Act, essentially? The legislature said, okay, you can't get this information in 4343.710, but maybe you can get it under the Criminal Records Act. Why does the Public Records Act even come into play then? Hasn't the legislature now determined there's a way to get these records and it's completely different than the PRA? Well,
Your Honor, I don't think the legislature has explicitly made that determination. There's no statute, there's no language in the PRA or the CRPA which states that certain records may only be requested under via CRPA, nor does it specifically mention the CRPA or 4343.710 in the PRA. And so the operative framework here is that the agency must find a valid exemption. And so it's not so much the question of, well, do I submit it under the PRA or do I submit it under CRPA or do I submit it under this or that? I'm entitled as a member of the public, as we all are, to submit a request for public records under the PRA, and then it's the agency's job to find a valid exemption. It is my argument here today that 4343.710, which is what State Patrol is relying on, is not a valid exemption. Now, there's no dispute whatsoever that what my request was, that I made a request for records as that term is defined under the PRA, and that they're public. The question only is whether the exemption applies, and in fact, in the briefing, the State Patrol did admit that those records do exist, that they have responsive records to what I requested, and it just won't give them because of a purported exemption in 710. And the reason that the CRPA becomes relevant is because it shows that there is a direct conflict in what the legislature is trying to do. The 43-710 says information contained in the files and records of the section relative to the commission of any crime shall not be made public. It's very clear. But the CRPA turns around and says, well, actually, conviction records may be disseminated without restriction. That's RCW 10.97.050 subsection 1. And so there's...
I have a question about the definition of conviction record
Okay.
in 1097.
Mm-hmm.
So that definition says that conviction record means criminal history record information relating to an incident which has led to a conviction or other disposition.
adverse to the
So
subject.
what do we make of the language saying that conviction record means criminal history record information rather than documentation or something else that refers to a physical or electronic record?
Well, what I would make of that, Your Honor, is that, again, I would emphasize that Look at this. I would emphasize that we're not looking for a statutory provision that authorizes release. What we're looking for, or what the agency is looking for, is a statutory exemption that prohibits release. I am presumed to be entitled to the records that I sent. And so the question isn't so much whether the conviction record is subject to dissemination or the CHRI is subject to dissemination under the CRPA. It's, is there a valid exemption? And I'm saying there is not under the CRPA or under...
But to do that, what you're saying is the CRPA trumps the specific language in 4343. So that's what I'm trying to figure out, is whether or not there's a way to reconcile those two statutes or whether or not they actually directly conflict.
I don't see a way I do not see a way to reconcile the statute. So, I do see a way to reconcile the statutes. I think the reason we need to get to reconciliation is because on its plain face, they do contradict each other so there has to be reconciliation because...
Well, 1097-050 contains permissive language. It says may be disseminated. It doesn't speak to which agency or entity is going to be releasing that information. And so, if you look at 43-710, it speaks to what the section of WSP can and cannot release as an agency. Mm-hmm. But 1097-050 can pertain to, just generally, to the extent that nothing else prohibits dissemination, these records may be disclosed. Let's look at the actual language. Freely disseminated without restrictions.
Right.
So that pertains to a sheriff's office or a police department or a municipal court or whatever agency the request is made to, provided that they don't have a statute barring them from releasing such a record. I think that's what 1097-050 is trying to cover, but it doesn't mandate release under that statute. It's permissive language.
Correct, but the PRA mandates release, unless there's an exemption.
Yes, and there is in 43-710 for the section, for the agency from whom you sought the record, and you wanted a source record, not merely information. And so, which is different here, because you concede in your brief that you are not entitled to non-conviction data.
Correct.
Right.
But the request I put in was for conviction records. So the
Conviction records can contain non-conviction data, though, can they not?
And the State Patrol could have released the documents and simply redacted the portions that are non-conviction.
And you could have requested the documents from the municipal courts or asked WSP to send them back to the municipal courts, correct?
I could not have requested it directly from the municipal court because they don't have them anymore.
But the WSP could have sent them to the court because their statute allows them to do that, correct?
That is the that's the agency's position. I don't have any argument counter to that. My argument, or procedure-wise, my argument would be that I'm entitled under the PRA to file my request, and they're required to file an exemption, and I'm not required to jump through any hoops in terms of getting a state patrol to send it to this court and then dealing with the court, et cetera.
Why not? I mean, it might have taken a little more effort for you to have WSP send it back to the municipal court, but that's not unduly burdensome when the enabling statute in question clearly prohibits this section of WSP from releasing this record.
With respect, Your Honor, I disagree, only because I deal with the smaller courts all the time, like the municipal courts, district courts, and finding anyone who knows what they're getting to a person that's top level enough to understand the concepts and work with me, even have the time to even work on that issue is difficult.
Well, that's really a different issue. That's not really before us. I mean, the difficulty you might have working with a particular municipal court.
I agree that issue is not before you, but again, with respect, I think your issue is what got us off track. Because again, my point is just that I'm entitled to file my PRA request, and they have to find an exemption. And if the court finds that the exemption exists, then I lose. But my point is that the exemption under the PRA, under case law, it has to be explicit and clear and unambiguous. What we're dealing with here is, if we put this in context, if we put 710 into context with the whole statutory scheme, not just focusing solely on 710, but looking at the criminal records availability scheme as a whole, we have to also consider that the CRPA is contrary to 710, and so that becomes, it makes the exemption not as clear, explicit, as ambiguous as required under the PRA.
So if you can see that you're only entitled to conviction information, what didn't you get that you would have gotten if you had gotten the heavily redacted source document? In other words, through Watch, you were able to get the information you sought because you've conceded that you're not entitled to non-conviction information.
Yeah.
So what would you have gotten from the source document, which would have been extremely redacted to only include very, very limited information? What didn't you get that you believe you would have gotten?
So the State Patrol has had an interesting tendency to misreport dispositions on the Watch report. And I actually was in front of this court within the last year arguing about that in Kinser versus Washington State Patrol. Unfortunately, my client lost that case. But the point is that I wanted to see what the court was reporting to the State Patrol, to see if the State Patrol, may I continue?
Go ahead.
To see if the State Patrol was correctly reporting the disposition. And the court disposition, the actual entries on the disposition report that would have been entered from the court saying what the disposition in court was, that definitely would have been conviction data according to the State Patrol, because they were reporting it as a conviction, so that would not have been redacted. And I would have been able to see actually what did the court report to the State Patrol, and is the State Patrol reporting that information correctly.
Thank you.
Now, I'm not sure how to proceed because I did reserve 3 minutes, and
That's fine.
then
We'll
I didn't think he was going to show up, so I kept going, and then, because I wasn't going to need the reply.
Yeah, you're eating into your rebuttal time
Okay.
now, but
So
we
I still
did
have 3
account
minutes
for your
then?
rebuttal
Okay.
time,
Thank you.
yes. We started. Thank you.
Good morning. May it please the court, my name is Justin Kato, Assistant Attorney General representing Washington State Patrol in this matter. First, I'd like to start by apologizing to the court for my tardiness. That was inadvertent, obviously. Mr. Kertchen is appealing the trial court order holding that RCW 4343-710 provides an exemption as an other statute for the purposes of the Public Records Act, thereby exempting the requested records from production and dismissing this matter. State Patrol is simply asking that the court affirm that record. This is the primary issue before the court, whether that statute operates as another statute for the purposes of 4256-070 and exempts these records. So the court is presented with two contrary interpretations of the statute. Washington State Patrol's is the unambiguous and the correct interpretation. The plain language, as I just stated, is unambiguous When interpreting a statute, the court's fundamental objective is to give effect to the legislature's intent. The surest indication, of course, is the plain language of the statute. This analysis includes not only the textual language of the statute, but the context of the statute as well as related provisions and the statutory scheme in its entirety. This includes the object to be accomplished by the statute, as well as the consequences that would result from construing that statute in one way or another. So with this in mind, there are three primary considerations that I believe that the court should look to in conducting the analysis here, the plain language analysis. First is the textual language. This is clear, unambiguous language. The statute states, information contained in the files and records of the section relative to the commission of any crime by any person shall be considered privileged and shall not be made public or disclosed. This language is not prone to multiple interpretations. There's one interpretation of this language, and that is the State Patrol's interpretation. And we can dig a little bit deeper in this as well. The context of this section and of Chapter RCW 4343 in its entirety creates a statutory scheme that provides funding to State Patrol's criminal history section by providing criminal history record information outside of the PRA and allowing Washington State Patrol to collect fees for providing those disseminations. Mr. Kertchen's interpretation would render these portions of Chapter 4343 meaningless.
So what do we do with 1097? 1097-050 says conviction records may be disseminated without restriction. So it seems like the argument is not as much it's ambiguous, is that it's directly inconsistent with another statute. So what do we do with 1097-050?
Well, before we even address 1097, Mr. Kertchen argues in his briefing that State Patrol presented arguments that were not made at the trial court level. State Patrol's essentially added an argument here addressing 1097 because Mr. Kertchen seems to have changed his argument between trial court and at the Court of Appeals. At the trial court, Mr. Kertchen argued that the records that we're talking about, these disposition reports, do not fall within the purview of 1097 because he argued that they are not criminal history record information. Of course, 1097 controls the dissemination of criminal history record information. So I think that if we're considering the fact that these records don't fall within 1097, then 1097 simply, I don't believe, does not apply to these records. They are still information contained in the files and records of the section relative to the commission of any crime by any person, but they are not criminal history record information under 1097. But even if we do look to 1097, I think that there are ways to reconcile and harmonize these two statutes. The first of these that State Patrol believes controls is the case of Wright v. State. In that case, it concerned certain juvenile records and looked to the statute that controlled those records. Now, that statute, which is RCW 1550-100, there is a specific exemption to those statutes, and then the statute also provides for dissemination outside the Public Records Act.
Under that line of cases, the statutory language, I think, if I'm remembering correctly, has language that says this is the exclusive means of obtaining these records. And so that clearly expressed a legislative intent to take that out of the public records analysis and make that that system the exclusive means. Is there any exclusive language in 1097 that you can rely on?
No,
similarly?
there isn't any language in 1097 that's as clear and decisive as that in 15.
And are there post-Wright cases that apply the same reasoning without that exclusivity language in the statute?
No, I don't believe they are. So essentially, I suppose, well, let me step back. So State Patrol is requesting or asking the court to extend the holding and right to apply to these situations as well. While there isn't exclusive language in 1097, I think that if we construe the statute in its entirety, that there is a legislative intent there, that this is the sole means, that it is intended that this is the sole means of disseminating criminal history record information. Essentially what 1097 does is it creates a statute that contains all of the same functions as the Public Records Act, but operates separately from the Public Records Act. It allows for the dissemination of records. It states when it's permissible to disseminate the records, when they must be withheld. It provides inspection rights for subjects of the records to challenge the withholding of records or the way that the agencies construe the records and report the records. And it provides an administrative recourse for those individuals if they feel that the agency is incorrect. And also importantly, it provides an injunctive, an injunctive action in superior court that provides for attorney's fees and damages. These are all functions separate of the Public Records Act. These are all functions that are also essentially provided by the Public Records Act, but there are also some key differences. There are at least two instances in which 1097 directly conflicts with the Public Records Act. One of those is that 1097 requires the agencies to track its disseminations. This is not allowed under the Public Records Act, and agencies do not have the authority to do that. And then, of course, 1097, kind of circling back to the fees issue, 1097 allows agencies to collect reasonable fees for the dissemination of criminal history record information, while the Public Record Act specifically disallows such an action. So I believe, looking back to Wright, circling back there, while there isn't explicit language that says this is the sole means of disseminating these criminal records, I think that when you look at the statute in its entirety, the context of the statute, that is the intent of the legislature for this to be the sole means of dissemination for criminal history record information.
So do we have to adopt this argument for an extension of Wright or an application of a similar analysis in order for you to prevail?
No, you do not. So that's where I return to Washington State Patrol's interpretation of this. I think that you can reach a conclusion that these records are exempt from production under the Public Records Act by solely looking to RCW 4343 and placing RCW 4343-710 in the context of that statute and what the legislature was intending to accomplish by creating the statutory scheme. What it is doing is it exempts these records from dissemination under the Public Records Act, and it allows for dissemination of the records in other places within this statute. Because State Patrol occupies a unique niche within the law enforcement, criminal justice agencies in the state, it is the repository for all criminal history record information. There are certain statutes that apply solely to State Patrol and not to other law enforcement agencies that allow that, while they don't allow, they dictate that State Patrol must disseminate criminal history record information under certain circumstances, but they also allow State Patrol to collect those fees. If the court were to reach a contrary position and allow for the dissemination of these records under the Public Records Act, there would essentially be no reason for anyone to ever request these records in a manner that would require them to pay a fee. If you can get them this way under the Public Records Act for essentially free or a very minimal fee, there's no reason that you would request them through the other manner in which it would require you to pay a fee to Washington State Patrol. This would essentially dry up the funding stream created by the legislature.
So what statute are we relying upon to talk about all these fees? Is that 43-760, or is that something else?
There are a couple of provisions that allow for it. For State Patrol specifically, these provisions are kind of sprinkled throughout RCW 4343. But if you can look to RCW 43-760 sub 4 815 sub 3.
That says charging fees pursuant to this section, and this section talks about fingerprinting and identity theft and things like that. It doesn't talk about the records Mr. Kertchen is looking for.
Well, those I think if you accepted in Mr. Kertchen's interpretation of this statute, the records that that provision is talking about would also be accessible through the Public Records Act. So I think that we can extend the reasoning here to apply to this statute or this section as well. And there are several sections such as that provide records, criminal history record information, conviction records to both law enforcement, to non-law enforcement agencies, I suppose is what it is, and require or allow them to collect fees as part of that, which provides the majority of the funding for the criminal history section.
So why didn't the legislature just say the PRA doesn't apply to these types of records? I mean, they didn't say that, right? There's nothing that says the PRA doesn't apply to the types of records Mr. Kertchen is trying to get.
No, there's nothing that explicitly says in the statute that the PRA does not apply to this, and that's why we look back to RCW 4343-710, which states that those kinds of records of the section relative to the commission of any crime by any person shall be considered privileged and shall not be made public. So that provides a general statute that provides an exemption under RCW 4343-710. And to the extent that these other provisions of RCW 4343 conflict with that, they create exceptions to the general statute, a more specific exception to the general statute. With my remaining time, I'll just quickly address the issue of attorney fees here as well, should this court rule in Mr. Kertchen's favor. He argues that attorney fees are available to a pro se attorney or an attorney acting in a pro se capacity. In making that argument, he relies on Lean v. Demopoulos, a case which created a case that required a case that looked to a contractual relationship between the parties to determine that party fees or attorney fees were due in that situation. Essentially what State Patrol is requesting is for the court to look to the case of K.V. Erler, a Supreme Court case which held that attorney's fees in these kinds of statutory schemes are not available to pro se litigants even when they are attorneys. I think that you can extend the reasoning there to the present case. There is case law holding that Washington courts should look to FOIA decisions because it is substantially similar to the Public Records Act and extend those holdings to issues under the Public Records Act. So with that, I would thank the court for its time. Again, I apologize for my tardiness, and I ask the court to affirm the trial court's holding in this case and dismiss this matter. Thank you.
Thank you. If the legislature intended to prohibit the dissemination of all information under 710, as the state repeatedly argues, then why would it go in 5 years later, in 1977, past the CRPA, and explicitly authorize the dissemination of conviction information? Because 710 doesn't on its face, specifically use the conviction or non-conviction terms. So the legislature essentially created a direct conflict. It authorizes in one place the same act that it prohibits in another place. And so this
Could we view 1097 as an exemption to the exception, or the exception to the exemption, I should say? So we have a clear PRA exemption, and now 1097 is simply an exception to that exemption. Why wouldn't that be a reasonable interpretation?
So So the CRPA is an exception to the exemption in 710. That may be a reasonable interpretation of how to reconcile the two statutes. However, what I would argue then is that we clearly aren't dealing with an explicit, clear, and unambiguous exemption, because we now have to add this whole layer of things on top. And so because the exemption then wouldn't be clear, unambiguous, and explicit, it would not apply to restrict the dissemination of the records that I specifically requested. This statutory scheme that the State Patrol is employing, it creates a dangerous precedent because it allows the State Patrol to pick and choose what it wants to rely on. It wants to sell information and make money on the watch report, then great, we can do that under the CRPA. It doesn't want to comply with my PRA request, great, we don't have to because we have 710. The State Patrol gets to do whatever it wants, and that's a significant problem. And so with that, I would ask the court to reverse and remand. Thank you.
Thank you, counsel. Thank you. We'll take a few moments for counsel for the second case to approach and get settled.